to like pour water on my head, like because I'm like trying to attract it's sort of like problematic now that I think about it. It's an older coach. I was a minor.
Sure. Yeah, this was a while ago.
We should update this. He's 19 and I'm 16 and I'm like trying to like get his attention. I'm just like pour this water bottle on my head, but they were like, you can't get your hair wet or it's gonna, we don't have time to change over and dry your hair.
Oh.
So just pour it on your face. And I was like, okay. And it was my first job. I was like, in my eyes, so I go like this and then I flip my hair.
I love
and it
a woman with bone dry hair.
Hi, friends. Hi, besties. Okay, the malignant persona of Blake Lively continues. If you haven't had a chance to check out my video yesterday where an insider from It Ends With Us spoke to me and someone that used to work for Wayfair Studios also talked to me, make sure you check out that video. But in that video, we talked about the malignant persona that is Blake Lively and the lies and the threats that she uses to get what she wants. And I would say that the threats that she's using and continues to use and the intimidation tactics are only getting started because Blake has been losing in the court of public opinion. And recently, Taylor Swift basically said they weren't friends anymore. And an allegation came out that, she might have threatened to release text messages of Taylor for 10 years if she didn't give her or support her or issue a public support note on social media about how much she loved her friend Blake. And Blake's attorneys got filed to strike it. It was struck. The judge refused to do sanctions and just gave a warning. Since then, Friedman and none of the attorneys on the side of Wayfair have said a peep to the media. Instead, it has been Blake's attorneys that can't stop talking to the media. So it's really interesting that this morning, after she's been getting bad PR about, possible threats of Taylor Swift and the Van Zandt sham, we know that Wayfair is in the process of looking to get sanctions and to file new claims against them related to this lawsuit that they filed, the Van Zandt Inc. versus Doe's 1 through 10, which was used to obtain the records of and the phone records of Jen Abel illegally. So Blake's attorneys know that there is stuff coming on the horizons. They know that they are likely going to have a new complaint ahead of them or possibility new litigation and sanctions asked for against them. And also Blake's evidence could very well be thrown out of the case. And so it's like clockwork, right? When somebody is on the losing end, Blake's team continues anytime they do something to expose something, her team retaliates with dozens of new filings. And I told you how they keep doing these negative filings against Wayfair to make them look horrible. And today, 2 new filings. One's a motion to compel about an investigation into claims of SH on the set of It Ends With Us by a third-party investigation company that happens to be doing an independent investigation for Wayfair about these claims after Lively made a complaint to the Civil Rights Department and filed a lawsuit, which under the law, they're required to do so, but they're trying to interfere in that. They're also intending to imply that there's been witness tampering here. Isn't that funny? Witness tampering and improper influence of witnesses in this case. And they're calling it a investigation that's a charade. So an investigation that was set up by Wayfair, who's an employer in the state of California, hiring an outside third-party law firm to do an investigation of the set of It Ends With Us and interviewing people on set to get a backstory about what happened. So if there was anything that Wayfair could have done, they can find out from this third party how to remedy it. And they call it a so-called investigation, and it's disingenuous, and it's a charade. They said they failed, though they were legally required to investigate her concerns when they were first raised in 2023. Had it done so, she would have participated in an investigation, and it would have substantiated the SH that she suffered on the set. I don't think she actually brought forth them in May of 23. She never filed an HR complaint. Mr. Baldoni's unsolicited discussions about his addiction to pee and his sex life and his improvised scenes without Miss Lively's consent. Oh, so now they've reduced the SH even more significantly. Far more. I guess they're getting rid of the photographs and the guy that was the person that worked on the set that he hired to be the OB. Did we forget about that? Anyway, and no more stuff against Mr. Heath? What's going on here? They say they waited years until January 25 to initiate this investigation. Under the guise of neutrality, they are doing a one-sided interview of unsuspecting third parties, potentially tainting the ongoing litigation while reserving for itself the option of whether it will release its findings or bury them behind a cloak of attorney-client privilege. Given their publicly stated foregone conclusion that the allegations are not true, they're not permitted to wield the attorney-client privilege as a sword and a shield, invoking the privilege for now, but insisting that it may waive it later at some unknown future date, presumably only if investigation yields a result that Wayfair likes, which it will no doubt publicly release with much fanfare. The motive is clear. They hope to conduct shadow fact discovery under the pretext of an attorney investigation to prevent Miss Lively from obtaining critical information until it is too late. Oh my God. So she's mad that they're doing an investigation into her claims and using a third party because then Miss Lively might not be prepared for what they find. Since late January, investigators Rains, Feldman, Littrell, LLP, and Adam Investigations Counsel have contacted potential witnesses and in doing so represented that they are conducting a neutral fact-finding investigation. Upon discovering this, Ms. Waverly immediately raised concerns directly to the investigators and to Wayfair about the investigation proceeding in parallel with discovery in this action and its purported neutrality. Given that Wayfair's publicly stated position and the risk of confusing or tainting witnesses, among other issues. If Wayfair knows it's false, but they can still do a third-party investigation and it can still be false. All of this is being done because Blake does not want to participate in this, and she doesn't want to go on record about what happened. And they're trying to cease and desist from them collecting evidence from anyone else on set that can either verify or corroborate the claims or dispute. Both Wayfair and investigators have refused to share any details about the investigation. On March 31st, Ms. Lively served requests seeking all documents and communications concerning the investigations, all notes, recordings, and interview memoranda, and documents identifying each person connected or interviewed. All communications between investigators and any person concerning the investigation. So what it sounds like is she wants evidence of an investigation, but she doesn't want to participate in it herself. They responded with boilerplate objections invoking attorney-client privilege and work product protection, while initially claiming they would produce relevant non-privileged documents within the possession, custody, or control during the parties' conferral. They represented that they did not have the investigation materials, and when asked whether they intend to assert attorney-client privilege, they responded that they assume, but we're not sure. The investigation materials are highly relevant, are necessary for Ms. Lively and the court to ensure the witness engagement has been proper and have been put at issue by Wayfair. They must be produced. They're not permitted to assert blank objections and categorically withhold documents. Wayfair has not come close to meeting its burden to show that attorney-client privilege or work product protection applies to the investigation materials. That's so weird. Didn't they say recently that they couldn't have anything related to Edgeworth security under work product doctrine because it was in preparation for litigation? And if this is a product of litigation that they're doing as a product of the litigation, wouldn't that also be work product doctrine under that same argument? They always contradict themselves. They cannot manufacture protection by rerouting an otherwise discoverable factual inquiry through attorneys. Wayfair waived any applicable attorney-client privilege or work product protection by, among other things, placing the adequacy of the investigation at issue, its 13th affirmative defense, the adequacy of their response to her workplace sexual harassment complaint is at central issue in this case, and the investigation materials are unquestionably within their possession or control. and they are allowing Wayfair to withhold materials on the basis that the investigation is ongoing or privileged, whilst reserving the right to reproduce later if deemed favorable, is highly prejudicial to Ms. Lively given the posture of this case. It deprives her of the ability to test the scope and credibility or timing of the investigation. You know, she doesn't want to give up any evidence herself, right? But if anything comes out that might not be favorable to her, she wants it. It's the entitlement of all of this. And on the face of this, I just think it's funny that they're automatically calling it a sham because I want to just show you something. They filed a bunch of letters here, okay? Now, in the state of California, if someone goes to the California Labor Department and they file a civil rights action and say that they were discriminated against or sexually harassed, an employer has a responsibility to do an investigation to verify if the claims that are being made against them, if they're valid. So when a complaint is made to their department, employers are they'll generally need to investigate the allegations if the complaint is accepted for investigation by the CRD. Now, Lively waived a formal investigation by the CRD and instead went to the lawsuit. Okay. And so even though she waived it, they hired a third party to do this investigation. And her attorneys are saying, you're not supposed to do this. It's wrong that you're doing this. It's too late that you're doing this. She doesn't have to speak to you. I mean, that's what they told you. Like, Miss Lively doesn't need to talk to you. You have no right to even try to talk to her. You're late on this. The investigation must be thorough. It must entail speaking to all of those witnesses and reviewing any relevant documents. It must be effective, designed to lead to remedial action. So here's the thing. She could have gone through the CRD and they could have done an investigation, but instead she waived it to go to a lawsuit. Wayfair decided to hire a third party to then go and do an investigation. And a third party neutral law firm was hired for this purpose. So that party they're called Rains, Feldman, and Luttrell. Okay. And on February 17th, this is what they said to them. We received your letter on February 14th declining her participation in the investigation of her claims against Justin Baldoni, Jamie Heath, Stephen Sarowitz, and Wayfair. While we acknowledge and respect your concerns, certain aspects of your letter mischaracterize our role and statements of the fundamental nature of workplace investigations. They claim that Wayfair retained our firm to investigate the claims made by Ms. Lively's recent legal fight before the California Civil Rights Division and the United States District Court, Southern District of New York. Your client contends the allegations surfaced years ago and should have been investigated. The scope of our investigation includes whether Ms. Lively filed complaints and whether Wayfair failed to investigate them. We will determine through this investigation whether a preponderance of evidence supports her claim. Even if Wayfair failed to investigate Ms. Lively's prior complaints as she alleged, Wayfair still must investigate subsequently filed complaints. Regardless of timing, once serious allegations come to light, a neutral investigation remains a necessary and appropriate step, and we intend to carry out that obligation in accordance with best practices. So their goal is to investigate, did she file a complaint? Did they fail to investigate? And even if they did, they still need to do this now, because then they would be failing to investigate again. Makes sense. You expressed concerns regarding the scope of the investigation, Wayfair's payment of our fees, and the absence of subpoena power. While Wayfair retained us, the core function of an independent workplace investigation is neutrality. They do not dictate our investigation nor determine who we interview. We pursue relevant facts, including information from witnesses identified by any involved party. Your assertion that Wayfair will determine who we interview mischaracterizes our process. They tell them that they rely on voluntary witness participation and they do not have subpoena power or other coercive measures to compel testimony. It's designed to obtain information from people that are willing to come forward. And it says that current company employees are typically required to cooperate per company policy, but external witnesses, such as former employees or third parties, may choose whether to participate. We make diligent efforts to identify and interview relevant witnesses, follow up with those who may initially be reluctant, and document any individuals who decline to participate. If a witness refuses to engage, that does not mean the investigation is ineffective. Rather, it's really inherent in the fact-finding process. To suggest otherwise would be to hold us to an impossible standard that's not aligned with how neutral workplace investigations operate. Your letter appears to frame these procedural realities as flaws, but in doing so, it creates a paradox. You acknowledge our role as an independent investigator, yet simultaneously critique us for not having powers that no independent workplace investigators possess. It is important to recognize that our role is not to compel participation, but to pursue the facts as thoroughly as possible within the framework of an impartial workplace investigation. Despite your client's decision not to participate, we remain open to receiving any information or documents or witness names that your client believes would be relevant. Our objective remains to determine the facts as comprehensively as possible, regardless of whether she actively participates or not. They explain how they're neutral, they explain their methodology, the effectiveness of their investigations. And then they also say that it's privilege. We acknowledge your concerns regarding the privileged nature of our investigation and Wayfair's ability to assert or waive privilege. However, as I trust you are aware, it is standard place and workplace investigation that the privilege remains with the employer. This does not mean we are beholden to the company. As we discussed, our communications with the company representatives during the investigation are limited to logistical matters and status updates, not the specific substance of witness interviews. We understand the skepticism surrounding our role, particularly given public nature of these matters. Our obligation remains to conduct thorough and impartial investigative consistent with professional best practices. So they asked to interview Blake. Blake says no, and then basically says, why are you doing this? It's too late. It's improper. You don't have subpoena power, blah, 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 all this stuff. And trying to make it seem like this is being done to get around the fact that they didn't investigate early on. And it honestly just sounds like they got the CRD complaint. They're like, we need to do an investigation of it. And they hired someone to do it. Okay. And then they sent another letter to them, basically telling them to cease and desist. Like, you better stop this investigation, like right now. Otherwise, we're going to sue you even more. And they're saying that it's going to taint and threaten witness evidence in the case. And they must stop immediately. And it was a cease and desist. She really loves cease and desist. And her cease and desist is implying that they're basically going to be tainting witnesses in the case. And the other one is that the primary source of the information that they're getting from this is from Wayfair. And Wayfair has already basically contested that this actually happened. And so how can they be neutral if they're being told by Wayfair none of this happened? And Wayfair appears to be attempting to ascertain how witnesses will testify in a closed environment and without affording Miss Lively or anyone else the opportunity to examine those witnesses. And they're accusing them of abusive process. Isn't that funny? Oh my God. Even when they try to bring someone in to do an investigation, they're accused of doing something wrong. They also said that it's egregious that they've done this investigation because it's being portrayed as neutral and independent, but that they've already gone on record and called her a liar and that she defamed them. And they claim that they would never voluntarily disclose a finding that Miss Lively allegations are substantiated. That meaning because it would require them to dismiss their claims against her. And it says, as a reminder to you, the client for which you are purporting to conduct this neutral investigation has in the last week, through their counsel, told the entire world in a statement to the media that Wayfair and its leadership are innocent and that Miss Lively claims of harassment and retaliation are an abuse of the legal system and pure malice, false, and fantastical. I mean, they are all abusive and false and fantastical. Wayfair has already admitted that Miss Lively raised concerns during production. Mr. Baldoni, who was the director as well as the co-founder and co-chairman of the studio that owned this movie, was her boss at every turn. And she claims that Mr. Baldoni spoke about his pornography addiction, divulged information about his sex life, made derogatory, degrading, and sexual comments, described his own genitalia, improvised intimacy that had not been rehearsed, choreographed, or discussed, casted his friend as the OBGYN. Oh, there it's back. And then they created a retaliation campaign, they basically said. We demand that you immediately cease and desist from further pursuing this sham investigation or from contacting any additional witnesses as a part of this. We further demand that you immediately disclose everything, blah, 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 communications with everything. So we want you to stop it, then we also want you to disclose it, including any introductory emails or letters. We also demand that you respond to this letter by March 31st. And if you fail to do so, we will promptly raise the foregoing with the court and seek all available sanctions against the parties and reserve all rights and remedies against you and your respective firms. They love to threaten sanctions at every turn. So on the one hand, they don't want them to do this. And on the other hand, they want all the information that they've gotten from the investigation. Wayfair has called her a liar, and I will say that's true. But if no sexual harassment happened, they can say that, okay? And if they know for a fact it didn't happen because they have it on video and they have the documented evidence and they know that she never brought the claim forward and she never filed a report, she never went to her union, she never filed a grievance, she never went to HR, never once. So they responded very, very harshly. We have had a chance to review your letter, and in it, you demanded that we immediately cease our independent investigation of her complaint against Wayfair. You further demanded that we identify every individual contacted and turn over all notes, communications, and recordings related to those interviews under the threat of court intervention and sanctions. The demand is baseless, procedurally improper, substantively indefensible. As experienced employment counsel, you are undoubtedly aware that the approach we have taken reflects not only legal compliance, but standard workplace investigation practices. Your letter reflects a willful mischaracterization of our role and the protections afforded to such investigations. Your letter appears designed to obstruct a lawful process and chill the participation of witnesses who might otherwise assist in a fair, impartial, fact-finding endeavor. I don't understand how this could be bad for her, right? If the witnesses come forward to the third party, not with Wayfair, Wayfair can still contend that they're innocent. But if third parties come forward and say something to them that's not favorable to them, they can't influence them to say anything that's false here, right? There's a lot of lights right now on Wayfair, and they would be stupid to do that. And thus far, I don't see them doing that. To reiterate what we told you on February 12th call and again on February 17th, we are not litigation counsel to Wayfair, and we don't operate under any litigation or public relations strategy. This is not an adversarial role, and we conduct our work free from external pressures, including those arising from pending litigation. Your assertion that we are conducting an illegitimate investigation bought and paid for is disingenuous. This investigation is timely. As soon as they learned of her complaint with the CRD department, they took steps to retain our firms to initiate and conduct a neutral workplace investigation to investigate any unresolved claims. As you are aware, they have the absolute right to conduct this type of workplace investigation, and they give some laws that allow it. Your claim that our investigation is a sham designed to interfere with litigation is equally baseless. If taken seriously, your position would effectively nullify the entire purpose of workplace investigations. To suggest that an employer loses its right and ability to investigate claims of misconduct merely because a lawsuit has been filed is unsupported by legal authority. To the contrary, courts have repeatedly affirmed that the pendency of litigation does not extinguish an employer's duty to investigate, nor does it negate the employer's right to gather relevant facts from willing witnesses, provided those efforts comply with applicable ethical and legal standards. Your allegation that we have misrepresented ourselves to witnesses is not only factually incorrect, it is reckless. In every instance, we have clearly identified ourselves as neutral investigators, disclosed our retention by Wayfair, and emphasized that participation is entirely voluntary. For any witness we believe may be represented, we explicitly request counsel's contact information and confirm that their attorney is welcome to attend the interview. These outreach practices fully comply with Rule 4.3 of both California and New York Rules of Professional Conduct. Your accusations to the contrary lack any evidentiary support and appear aimed solely to undermining the credibility of fellow members of the bar without cause or justification. It's amazing that they keep trying to abuse processes and make intimidating threats when they're the ones doing it. It's like every accusation is a confession. Your claims regarding privilege are similarly misplaced. Independent workplace investigations conducted by outside counsel are routinely protected by attorney-client privilege and attorney work product doctrine. As the courts have held, this confidentiality is not a flaw, but a feature. It ensures that employers and investigators gather facts candidly, confidentially, and fully. The public nature of this litigation only reinforces the importance of preserving confidentiality throughout the investigative process. Public scrutiny of an ongoing investigation can compromise witness candor, distort facts, and undermine the very neutrality we are bound to uphold. Even if Wayfair to waive attorney-client privilege that would not and could not compel the production of attorney work product, which the investigating attorneys hold. And they're saying that this is protected to preserve the adversarial process. The notion that witness interviews may only occur through adversarial deposition is not supported by law. Courts have repeatedly recognized the rights of parties, including non-litigators such as workplace investigators, to conduct interviews with witnesses outside of formal discovery. Investigators are not precluded from speaking to individuals with relevant information, and those individuals remain free to decline. We see no basis for ceasing an investigation authorized by federal and state law, and we have no intention of doing so absent a court order. We will continue to conduct ourselves in accordance with standard practice and our legal and ethical obligations as court officers. Moreover, we hereby demand that you discontinue making false and meritless assertions and reserve all rights, remedies, and privileges. Your cease and desist letter constitutes unlawful interference with an ongoing investigation and is plainly meant to try to intimidate participants and obstruct the process. Finally, we understand that you have asked us to accept service of subpoenas directed to members of the investigative team. We do not believe the subpoenas are appropriate or enforceable given the legal protections discussed above, but in any event, we will not be accepting service. We remain committed to conducting this investigation with the independent professionalism and integrity that it requires. So they're trying to do this investigation, and even within the investigation, they're trying to stop it and say that you need to stop it because you're going to influence witnesses. And if you influence witnesses, then it's going to harm us. And then if we don't know what they said, we can't be prepared for court. But under the law, they are 100% allowed to initiate an independent investigation into the claims by a neutral third party, even after the commencement of a lawsuit. In fact, they're not only allowed, but they're required to do so. And so she's trying to, on the one hand, say, this is improper. You failed to investigate. I can't believe you did this. You're doing this to intimidate witnesses. But then on the other hand is saying, I want all of that information that you're getting. It seems like an end around to get the information that they don't have access to. They want to know what people are saying, but then they're also saying that Blake won't comply, and she's implying that the attorneys that are involved in this will somehow be abusive and not intimidate witnesses and force them to say things that aren't true. I kind of agree with the way that they said it, that it seems like they're trying to interfere in this investigation and they're trying to stop them from doing the investigation, which is really weird because this is what Ezra wants them to do, right? Unlawful interference with an ongoing investigation, trying to intimidate participants and obstruct the process, intimidating them to stop the process, to stop them from talking to witnesses, right? Intimidate them to not do the investigation. If she wasn't sexually harassed, or if she was, you know what this investigation could do? It could show them the flaws and what they should have done at the time if they're going to be transparent, right? But because no sexual harassment actually occurred, they want to stop this, in my opinion, because they don't want the negative report to come out. They don't want it to show that Blake Lively lied, that there's no evidence. So instead, they're trying to do what they're accusing Wayfair of doing and bury it, but then run to the court now and say they need to hand over everything to us. What I see in Blake's attorneys is that they have an out of control client and they are filing all of these motions and documents and they're doing all of these intimidating steps because they're being directed by their client to do this. Blake keeps talking about how Steve Sarowitz has $100 million, right? And that he's going to use it to destroy her. Actually, I think he said he was going to use it to defend himself. But either way, she keeps saying that they're doing all of these things and they're going to file all of these things, but she's the one that continuously is filing it in court. Give me this, give me that, stop doing this, stop doing that. Now I want sanctions. She is clogging the court docket with motions to compel. There are still, I don't even know, 5 outstanding motions to dismiss that the judge has yet to rule on. And then even before he has a chance to rule on a motion to dismiss, now she's trying to bring sanctions against Wayfair, not Wayfair, against Jamie Heath, Steve Sarowitz, Melissa Nathan, Jen Abel, and It Ends With Us LLC for filing a frivolous lawsuit against her. Even though the case hasn't been ruled, the motions to dismiss haven't been ruled on yet. So she's asking the court to already prove that it's frivolous before they've even ruled on the motion to dismiss. And every single time she files something new to the court, she's going to cause further delay to the court because now the judge needs to rule on all of the motions to dismiss. Also, he now needs to rule on all of these outstanding quashings of subpoenas and motions to compel. He also now needs to, review this sanctions one where she's trying to get them to give her money because they filed frivolous lawsuits against her and used improper group pleadings, and her motion to dismiss is so valuable and so good, it's going to be absolutely granted, and further driving home that Wayfair has already been told by the court of the flaws in their case and the flaws in their pleadings. And they're trying to claim that the judge told them that it had flaws, which it did not have flaws. The opposing sides say that the case has flaws. That's what they do with motions to dismiss. That doesn't mean it'll be successful. And so before the judge can even rule on a motion to dismiss, they're going to ask the judge to now give them sanctions for filing a frivolous lawsuit. And the motion for sanctions is bananas, and I'll probably get to that in another video, but they're trying to get these sanctions on what's called a Rule 11 violation, which is used for the most frivolous lawsuits with no basis in reality. In fact, there's the It Ends With Us or It Ends With Lawsuits subreddit, and there's an attorney here in that there's a bunch of attorneys there, okay? And this is what they said about the Rule 11. Lawyer here. Rule 11 exists in virtually every jurisdiction and in every state. It's basically a mechanism to prevent lawyers from filing frivolous, baseless lawsuits. Usually, this has to be so frivolous and baseless to the point of outright lies, or not even having a colorable basis in law in order for these types of motions to be granted. It's a real remedy, but it can be very serious. What I personally find odd about this is the timing. My understanding is the court has not decided on Lively's motion to dismiss, so this issue does not seem ripe, meaning if the judge had granted the motion to dismiss, they would have had much stronger basis for bringing Rule 11 sanctions, but he hasn't. So this seems like it's going to be denied. This is coming from another lawyer. To me, this seems like a pure PR move. I'm sure Friedman has something up his sleeve. He knew when he kicked the hornet's nest with the Taylor Swift stuff that they would come after him. And then they further reiterated and such, it's definitely PR. It could also be a way to flush out their evidence. They know a motion for sanctions is coming against the Lively camp for the Van Zandt sham subpoena and the Taylor Swift stuff. They might want to see what else they have. Might also be a way to put them on equal footing with the judge insofar as, well, Baldoni is alleging that we are bad, but they have been bad too. And look at this sham lawsuit they filed. Only time will tell. So they're basically trying to accuse Wayfair of filing a sham lawsuit after they were accused of filing a sham lawsuit in order to get subpoena power. They didn't initiate this idea of filing a sham lawsuit until April 23rd, months after the lawsuit was filed. Months. But they only initiated it after they were put on notice about their sham lawsuit. So it seems like the timing here is suspect. All of these filings, again, they just clog up the legal process. They're abusing the legal system. This judge, it's going to delay the case. It's going to delay the findings of the case. It's putting more work on the judge and on the clerk and on the court. It's more taxpayer money. Also, she can just continue to put PR into the media through court filings to try to paint them as not complying. And will some of the filings go in her favor and some not? Probably. But all this to me is showing someone that is trying to win favor in the public narrative, trying to continue to slander and abuse them through the court system, and just blatantly throwing crap at the wind and hoping something sticks. And she's trying to get out of these lawsuits. She's trying to impede the investigation. She's not willing to participate and invest in the sexual harassment side of things. She has foregone every attempt for them to investigate this claim. She didn't ask the federal government, the EEOC, to investigate. She waived the investigation with the CRD. Now she's trying to get them to stop their own independent investigation and then suing them for not investigating. All the while then demanding all the evidence they've obtained through this, which is illegal, and then again wanting sanctions to say that they've been filing baseless lawsuits against them when they're the one that's been accused of actually filing a baseless lawsuit that is absolutely frivolous. Even if some of these claims are dismissed by the judge, they will be given a chance to amend because they will likely be dismissed without prejudice. And without prejudice means you can amend. That's how it works. I don't know. I would be exhausted, absolutely exhausted if I were Baldoni and Wayfair right now. She is out of control. And if the last day of filings isn't any indication of her malignancy, I don't think anything else could be better shown for this. So tell me what your thoughts are about her intimidating witnesses and interfering in investigations and refusing to participate in an investigation of sexual harassment. She has the opportunity to literally provide feedback, and she's refusing. Tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.